Welcome to Work-Based Learning, Labor Laws, and Legal Issues. I'm sure you've been waiting all day to hear about this. We've got a great panel of experts, so I'm very excited to share their expertise with you this afternoon. I'm Kelly Deemer from the Iowa Department of Education. I'm the Education Consultant for Business and Marketing, Entrepreneurship, and Work-Based Learning. And I'd like to welcome you to the breakout session. All audience members should have a note card. If you don't, please let us know. I would ask that you write your name on the note card and your email address. The format for this afternoon's presentation will be each of our three panelists will be speaking for 15 minutes on their topic. While they're speaking, if you could jot down any questions you have. We want to make sure we get through all the material first. When we're done with the three panelists speaking, then we will go to answering your questions. If you have questions that are not answered, we ask that you hand in the note card. We will email you back with the response, and we will be putting together a frequently asked questions so that everybody knows the questions and the answers to everything. So if you could write your name and your email address on the note card, you'll be all set to go. Any questions? We're doing good, okay. So I'm very, very pleased to introduce a panel of experts on the topic of labor laws and legal issues of work-based learning, which will include liability issues, child labor laws, and teacher licensure. With us today, we've got Robert E. Jester, President of Jester Insurance Services. We've got Melissa Wright, the Community Outreach and Planning Specialist with the Wage and Hour Division of the U.S. Department of Labor. And we've got Dave Wempen, the consultant from the Iowa Board of Educational Examiners. So with that, I'd like to turn over the first 15 minutes to Robert Jester to speak on liability.
Yeah, it works, doesn't it? Thank you, Kelly. The nice thing about this subject when we talk about school to work is that we don't have to talk about liability. It used to be, before Senate File 371 passed, we had liability issues that were fairly significant, and actually they were so significant they were just about on the verge of killing this program. I don't think it would exist today had we not changed the law, because we were starting to see, and we did see, students who were in the workplace got injured, and before that change in the law, they had the ability to sue the employer, they could sue the school, they could sue both of them. In some cases, they could collect workers' compensation and file a suit on top of that. So it was a bad situation that we fortunately were able to rectify, and Iowa law now, I think, is very progressive on this issue. So what we've done is to basically take liability suits off the table. A student injured in a school-to-work setting no longer has the right to sue anybody, the employer or the school to-work coordinator or anybody else. The law clearly now says that workers' compensation is the exclusive remedy for student injuries. And that means that there isn't any possibility of a lawsuit. The way it works is if a student is working at a private employer and getting paid for that work, just like an apprentice would get paid, then if they get injured on the job, that employer's workers' compensation insurance will pay the student injuries just like any other employee. Wouldn't be any different. The medical, lost time, scheduled injuries, death benefits, whatever, it would be paid just in accordance with Chapter 85 of the code like any other employee. But that student has to accept the workers' compensation because they don't have the right to sue the school in a case like that. And we had, before the law changed, 2 or 3 cases where the student got injured at an employer, collected work comp from the employer, turned around and sued the school on top of it. That's a bad deal. So that can't happen anymore. If the student is not being paid, if this is just a job shadowing kind of a thing, they're mentoring some person or persons or a department, but they're not getting paid by that employer, it's just part of their curriculum, they're still covered by work comp, but it's going to be the school workers' compensation insurance that will pay. And that's pretty unusual because normally students are not covered by workers' compensation anywhere, but in school to work they are. When they're in a bona fide school to work program as part of their curriculum, they're getting credit for it, then the school's workers' compensation policy will pay their injuries, pay medical bills, scheduled benefits, death benefits, whatever the benefits are called for in their injury. The school work comp policy will respond. But the good news here again, now that student, once they collect workers' compensation from the school, can't sue that private employer. So the private employer doesn't have to sit around and worry about, gosh, I'm going to have these kids in my workplace and I've got all this liability exposure. You don't have any liability exposure because they can't sue you. Now, does that mean you can relax on safety requirements? No, of course not. But you have safety culture built into your program and for all of your employees, so it's really not a problem. Now, people say, well, boy, if we have students getting paid under a school workers' compensation policy, what does that do? Well, so far the answer is not much at all. We've been very lucky since this law has changed that we've had virtually no incidents that I'm aware of any size. There might have been a minor medical thing or two, but I'm not aware of any school in the state of Iowa where they've had major losses, because it could, if it happened, it could increase the school's workers' compensation policy, just like any other claim would. But quite frankly, in the last several years since we've had this, it's almost non-existent. So I'm very pleased over that. It tells me that places of work really are pretty darn safe. It tells me the schools are doing a good job of placing students and getting that done. Now, this all sounds really simple, and it is, I think. There are, of course, some complications. There always are. One is that once in a while, people will get hurt going to work, and that's not covered. The workers' compensation law in Iowa clearly says that commuting to work is not covered under the Iowa Workers' Compensation Act. So if you have a student going to a place of work, driving their own car, I don't care how they're getting there, but they get injured, let's say in a car accident, that's not a covered incident. And it doesn't make any difference whether they're getting paid or not getting paid, but workers' compensation does not pay for commuting type injuries. A lot of people think it does, but it doesn't. The law clearly says that you have to arrive at the employer's place of work. Could be out in the parking lot, but you have to be on their place of work before workers' compensation coverage is triggered. Now, as a part of this, I would urge you not to start getting into the transportation business of sort of promising to get kids at these employers. I would just say, look, here's your class. You've got to be here at this organization or this company or this hospital at such and such a time, and leave it at that. The kids can find their own way there. They can walk there. They can ride a bike. Their parents could take them. But don't try to get into the business of hauling them around, because now you've just created more problems and more issues than you need to. One of the schools one time, when this first started, thought it'd be a good idea to have one of the other students take several of the kids over to this employer. And they thought it was such a good idea, they told the kid, well, look, Fred will pay you mileage. Well, now, that's not a good idea. Fred, first of all, was 16 years old, and I don't know if that's ever occurred to you or not, but a lot of 16-year-olds are not really very good drivers. In fact, they're pretty bad. And so I don't think it's really a good idea to have those folks driving around on your nickel. Because once you do that, you now have brought all their accidents in under the school liability insurance, according to Iowa code. Not a good idea. So I just let the people get there however they want to get there, unless you want to take them in a yellow bus with your driver. You can do that. But I wouldn't be promising to take people or get them there. That is a serious problem. It's very so far, we haven't seen any negative impact, but I'm saying that's, I think, because people are doing a pretty good job. One of the things you need to check out, if you know a student's going to be getting paid, so you're relying on the workers' compensation coverage of an employer, could be a hospital, could be a city, could be all sorts of people, you need to get a certificate of their workers' compensation insurance. I think that's an absolute must for every school to work coordinator to have that. Now you say, well, everybody has workers' compensation. They're supposed to have workers' compensation under Chapter 85 of the code. It's a Class D felony if they don't. But people do all sorts of strange things. They have their insurance canceled for non-payment of premium. You just don't know. But the only way you really know is ask that employer for a certificate of their workers' compensation insurance, and you should have that on file on a regular basis. So if it comes up for renewal, then you need to get another copy or another certificate of the next year's insurance. I would suggest your agent for the school could be a great help here. If you have questions, ask the agent to look at the certificate, ask them for questions. Obviously, I could ask me about questions, but your own agent, I think, can do a pretty good job. Kelly, how are we doing on time? Pretty good. One of the complications that we've run into are with farmers. And here's the issue there, because I know this has happened. Farms are an interesting problem. We have a lot of them in Iowa. They're also extremely hazardous. Farming is one of the most hazardous occupations there is anywhere. It's just a fact of life. They're working with a lot of machinery, where they're working on sloped land where the tractor could turn over. Farms are a workers' compensation issue. Under Iowa law, an individual farmer does not have to buy a workers' compensation policy if he doesn't want to. He can opt out of it. But the minute that farmer hires a part-time kid in a school to work, then he'd have to buy a work comp policy. So you could have a situation where a person who normally doesn't have work comp, doesn't think he needs work comp, all of a sudden, because of school to work, now he needs it. And this can be kind of tricky because the premium for farms is not exactly cheap. And you may run into some pushback from the farmer saying, boy, I don't want to spend this kind of money because I don't normally buy it myself. And he's right. But when school to work, there isn't that exception. Even one part-time school to work student has to be covered by a workers' compensation policy. So when you ask for certificate of insurance and you're talking to a farmer, you might get a pushback. Now, one of the other things, I should have mentioned that this applies to community colleges. It's not just K through 12. So it's K through 12 schools and community colleges are both covered by this provision in the law. Now, there could be some instances where people are on the borders of Iowa. They're in Council Bluffs, they're in Sioux City, they're in Davenport. They're sending kids maybe across the border so that they aren't necessarily working in Iowa. They may be working in Illinois. Now, if the kid is not being paid, it's still going to come back to the school's workers' compensation policy, still. But I don't know what the laws in Illinois say or the laws in Minnesota or Nebraska about student to work. So there could be issues with the employer and liability exposures that they have in those other states that we don't have in Iowa. But that is a slight little complication that you might run into. But I think those really are the main things. I do think it's also important. If I were a school to work coordinator, I'd want to go see the employer. I'd want to walk around and take a look at it. I'd want to kind of see what kind of a place of business am I sending kids. Obviously, most of them are going to be just fine. But some things, particularly in a manufacturing environment, auto body shops, some of those things can be a little bit on the ugly side and may not be a place where you'd want kids to be going. Well, Kelly, I think I'm about at my end of my rope here.
I don't think you're off the hook.
I think I'm off the hook.
Question at the end, but thank
Okay.
you.
So I'll pass this to Melissa. I think she's going to talk.
All right, I don't think I can sit still. I have to move when I speak, so. And I don't know how great I'll be at holding the mic because I tend to talk with my hands. So we're going to go ahead. As she stated, I am Melissa Wright. I'm the Community Outreach and Resource Planning Specialist with the Wage and Hour Division in the U.S. Department of Labor. So we're going to be talking about federal child labor laws, not state. I just like to clarify that. Before every presentation that we do, we're required by the federal government to give you a disclaimer that says the Federal Register and the Code of Federal Regulations is the official source for all regulatory information. Therefore, I could lie to you, and if I do, there's the disclaimer. So you can go ahead and skip. All right, so before child labor requirements, if you have a child working for you, anybody under the age of 18, federal law only applies to you if there's coverage. So there's enterprise coverage and there's individual coverage. Most employers are probably going to be covered. It's probably about 98% of them that are. So if it's enterprise coverage, it means that it's like a big umbrella and it just covers everybody. Everybody, no matter what they do. Individual coverage means that the employee themselves, they do something where they engage in interstate commerce on behalf of the business, and so therefore they have individual coverage, which means the Fair Labor Standards Act, which has all the child labor regulations, applies to them. Once you have coverage, then, you got to say, okay, I have federal law, and now I also have state law. And of course, sometimes they're different, and sometimes some are more strict, and then some are more lenient, and you get employers that don't know which way they're supposed to go. Just go with the more protective standard. As long as you apply the stricter standard, you'll always be in compliance with the less strict standard. And of course, you also have instances where you have like, state law might require something along the lines of like a worker's permit, or maybe it requires meal periods or something for youth, and federal law does not. You abide by the state regulation because it's the stricter, and then vice versa for the federal. So you just need to make sure that you're in compliance with both. When we're looking at child labor, probably if you're not dealing with 14 and 15-year-olds, and I don't think we necessarily were because we were talking mostly about community college programs. I don't think too many ninth graders are participating.
It would be high school, but most of them are seniors, probably juniors.
Right, from the information you gave me. Right, so we're looking at 16 and 17, 18-year-olds. 18-year-olds, none of it applies to them anyway. They're adults. 16 and 17-year-olds, when we're looking at that, we're mostly looking at hazardous order occupations. So the hazardous orders, when we're looking at that, we're saying that these are certain HOs that the Secretary of Labor has said, kids can't do these, period. It's, they've just declared them to be hazardous to their health and to their well-being, so therefore they can't do them at all. There are exemptions for those who are part of a student worker program. So we're going to go through like a big rundown here. So you have your manufacturing and your storing of explosives. I don't know how many of you guys have kids doing that. I hope not. I don't think that applies to most people here. So he was talking about driving. If you had like a student that was going to be driving other students on behalf of the employer or on behalf of the school to the place of employment. If you start getting into that tricky area, then you might find yourself in violation of HO2, which is, of course, driving a motor vehicle. Even if they're licensed, they're still not supposed to do that as part of their job or as part of their constant work. So once it is assigned to them as a study task, 16-year-olds can't do it at all, and 17-year-olds, they shouldn't be doing it except on very intermittent basis. So you might have a like an occasion where, we need somebody to run to the bank and hurry up and cash these checks or something like that. It's a one-off. It's not more part of their normal duties, so therefore it's okay. They are a licensed driver. They're the age of 17, and you do have that on record. But if it's a 16-year-old, it's a no-go. And 17-year-olds, it's really got to be incidental to their work and not part of their regular, duties. So that being said, power-driven woodworking machines are part of the exemption that we have. So we have, what is it? I believe I wrote it down here. Let's see. So we have exemptions for HOs 5, 8, 10, 12, 14, 16, and 17. So when we say that, we mean that any apprentice or any student learner, so you have somebody who's in a bona fide registered apprenticeship program, or you have somebody who's enrolled in a vocational education training program, those may be able to qualify for the exemptions that we have for those particular HOs. Go ahead and skip. So we have 5, which was woodworking machines, and then we have 8 power-driven metal forming, punching, and shearing machines. The meat processing machines, anything to do with like slaughtering and meat packing plants and such. And then, of course, your paper balers, your compactors, and 14 and 16, I believe, are, if you want to skip to those, the circular saws, band saws, guillotine shears, and of course roofing occupations, and then I think 17 is as well for trenching and excavation operations. Those have specific exemptions worked right into the law, and when we say there's an exemption, it doesn't mean that they can go ahead and they can do any part of it, because that would not be accurate. I do want to back up for just a second to 8 really quick. Well, actually don't. Just keep going. See, this is why it's weird for me to have somebody else controlling. So when we talk about operation, if you read the actual the HO and it says they can't operate any of this machinery, they can't work it, they actually define what it means to operate. And it means the setup, it means the adjustment, any repair, any oiling, any cleaning of the equipment. So even if it's already taken apart and you have a kid that's just going to wash it, which we see that a lot, they're not even allowed to clean it. So be aware that even with the exemption in place, you know, you're going to have issues with that, because the exemption covers only specific aspects, and it has to be incidental to the training. It can't be like, oh, this is something they do unsupervised all the time, and they can just have at it. So HO8, I want to point out really quick, because if there is, when we say metalworking machines, there are a very large group of metalworking machines that are known as machine tools, and they are not part of this HO, and it's often thought that they are. So when it says bans the operation of certain power-driven ones, it really means that anything that's part of the machine tool category, so you might have like your wire cut electrical discharge machines, key machines, bolt threadings, stuff like that. I would look it up on the Department of Labor website, because there are very specific ones, if that applies to you, that it does not cover. So the limited exemption, like I said before, it doesn't mean that they can do anything within those categories, within those HOs. And I'm actually going to take it right out of the regulation, because it's long, so, and I kind of condensed it somewhat. So you have to have, the student learner has to be enrolled in a course of study and training in a program, a vocational training program, has to be recognized by the state, and that they have to have a written agreement between the employer and the student program. And it has to agree that the work of the student learner in the occupation, it may be potentially hazardous. They need to be aware of that. It has to be incidental to their training. So if they're doing it, it has to be just something that is done to train them. It's not something that they're assigned as a full-time, that's what they do all day. And the work has to be intermittent, it has to be for short periods of time, and it has to be under the direct and close supervision of a qualified and experienced person. The safety instructions that have to be given to the student, they have to be given by the school and correlated by the employer with on-the-job training. And they have to have a schedule of organized and progressive work that sort of leads up to it. They don't just like pop them in there and suddenly they're supposed to know what they're doing. It needs to be a gradual.
If I could say something. If I could jump in for just 1 second. The 2 points that she mentioned was the agreement between the school and the workplace and the student. That's your training agreement, and that's, you know, who's responsible for what. And then the other one, the progression of tasks, that's the training plan. Both of those are different documents, and both of those are required by child labor to say that these are covered, and this is actually a school to work type of situation, and thus it is there's some exemptions with the hazardous occupations. But you got to have a training plan and a training agreement in place for that. Go ahead.
Right. So, that being said, yes. So, that being said, I have like this little slide here that has like the tips for employers. When it says verify the age of your young employees, oddly enough, the Department of Labor, when we say you have to verify the age, you have to keep their birth certificate or something along those lines on file. It can't just be like a student ID card. It can't be a driver's license if they're old enough. It has to, oddly enough, the Department of Labor doesn't consider a driver's license to be a legitimate form of ID. So you could use the family Bible, oddly enough. That's actually in the regulation. But a birth certificate is probably a copy of their birth certificate is probably your best bet. So, I don't know. It is what it is. So, make sure that you know the child labor laws as you go through. If you have somebody that's 15 instead of 16, maybe they are a little bit older, they got moved up a grade and they're participating in programs like this, you need to make sure that you're abiding by the rules for 14 and 15-year-olds as well, because there's a whole host of other rules that apply to anybody under the age of 16. It's not just HOs then. Now you're talking about Regulation 3, you're talking about hour standards, you're talking about a lot more information that you need to know in order to employ that person. And of course, you need to train the managers. Make sure that your managers are aware of what those kids can do and what they can't do. Because if they're the ones that are going to be working most directly with them, and make sure that the kids are educated. Make sure they know what the rules are and what they can do and what they can't do. We have a whole youth rules program, and I've gone to schools and have actually talked to students and told them, this is what you can do, this is what you can't do. Don't get your employer in trouble by doing something that you're not supposed to do, especially when they've told you not to. With that being said, I want to No, you were good. See, you were on the ball there. So the later one is the last one on this list. Encourage minors to say no if they're asked to do something that's prohibited. I can't stress that enough. If they don't feel that they can do it safely, even if, let's say they have been trained on it, let's say that, it is something they're allowed to do, but they don't feel like they're ready yet, I wouldn't be having them grabbing, equipment that maybe could possibly cut their hand off if they don't feel safe enough to do it, that they really don't feel educated enough to participate in that. So encourage them to say no and to move at the speed that really they feel they're educated to do. And then make compliance important, not only within, like with the students, but also with the schools. Make sure it is within the employers and the managers that are actually working closely with these kids. If you have trainers that are on-site training them, make sure that they feel that compliance with the law is just as important as, teaching the child what's in the program, because they don't want to do it outside the law and get everybody into trouble because, the program could be yanked by the Department of Labor and then it's not authorized anymore and then you have a whole problem on your hands. So you want to make sure that everything's above board and everything's in compliance with the law. And we have stickers. It says post-warning labels. We do have stickers that's available on our website. We have them at the Wage and Hour office. We have certain stickers that, when they can't do something, it just says stop. And it tells them, minors can't be operating this piece of equipment, and so forth and so on. So we have a few different types of those. I encourage you to print some off or to come down to the office and pick some up because we have a ton of them. And then, of course, if you do have somebody that is under the age of 16, make sure you're looking at their time records. Make sure they're not working outside of the hour standards that they're allowed to, because 5 minutes can get you in trouble. 1 minute can get you in trouble. It becomes an hour standard violation. And what we see is we have people working right up to the hour standard cutoff. So they schedule them and they say, oh, it's good because they're only working till 7 o'clock, not calculating the fact that maybe the kid might be 3 minutes late wandering up to clock out and everything else. And now it's got, this 7:03 tag on the time record. So I don't know how I'm doing for time. I feel like I'm rushing along.
Oh, you're doing perfect. You're winding down.
So wageandhourdol.gov. We have an awesome website. I really can't say enough about our website. I think it's fantastic. We also have a youth rules website that's not listed up there, but we do have it. I would go to it. It has a ton of information. And you can also call the 1-866-4-US wage number. That will route you to our Cedar Rapids office. Actually, it routes you to supposed to be the nearest wage and hour office that you call from. If you call from Iowa or Nebraska, though, it's going to route you to Cedar Rapids, because that's just how we have our phone set up. So it's going to route you to Cedar Rapids, and we have somebody whose full-time job is to answer the phones and really to answer the questions and make sure that everybody can, be educated and get their questions answered. And if he can't answer it, he'll find somebody who can. So you can also always go to your nearest wage and hour office, because we are, we're just a few blocks down the road, actually, at the federal building. You wouldn't know by the time it took me to get here, but is that the last slide? Oh, look at me go. All right, so if you have any questions at the end, I really encourage you to write them down. I'll be glad to answer them if I know the answer. If I don't, then I'll find it. Thank you.
Last but not least.
Yep. Our agency is mainly tasked with licensing teachers, administrators, educators in the state of Iowa. And when this work experience started to become more important in the past couple of years and more schools were doing it, we worked with the Department of Education, Kelly and I, quite a bit together to really make sure that this multiple occupations endorsement got to be a part of that program. So we would have licensed teachers supervising the students when they did those experiences for a couple of reasons. One is these people are the connection between school and the workplace. So they often do things at school that help train the students of simple things like how to show up for work, how to be appropriately dressed and presented, how to speak to people when they're at those places, but also go out in the workplace then and make sure that the placement is providing them the experience they need, make sure that it's a good environment for them, and asking the workplace employer that for feedback if the student needs to improve in areas. And the other tier that's beneficial for our licensed people is ethics. The people that are licensed properly with this endorsement then are covered under the Board of Educational Examiners ethics requirements, and we feel that's an important part for a number of reasons. So our endorsement requires that the student have the teacher has a secondary teaching endorsement, grades 5 through 12. As we've said, mostly it's high school students participating here. It's required for the teachers that are supervising the students. It is not required for teachers if they're within their own area. So that's where the multi part comes in. So if we have a language arts teacher and they're going to go supervise a student who wants to do a journalism experience at the local newspaper, that teacher would not have to have the MOC endorsement. There's many other examples that we could throw into there, but I won't dwell on those. You could ask me specifics for that later. But if the teacher is supervising students in multiple areas, then they need to have this particular endorsement. Current requirements are that they have 4,000 hours of career experience, vocational areas, and take 3 courses for UNI, Iowa State, or Drake have these courses. Some career and technical teachers already have 1 or 2 of these. The simple ones to click off are industrial tech, family consumer science, business education, and agriculture. Those 4 typically have kind of a step down the road already into it. Other teachers would have to take currently all 3 courses. We have a separate type of license within our agency that is called a professional service license for counselors. They're not trained as a teacher, they cannot get the MOC. Another option for districts is the work experience coordinator. This is under our special education rules. So for special education students that have an IEP goal for them to do workplace experience, and a lot of times that's then connected through the IEP that they have to have a training goal and they have to have ages 14 and up. Rules require them to have a career goal and how to get trained for that. So the special education teacher if they're the coordinator of that and they're aligning and doing the placements for the special education students, they have to seek the WEC. And it's also courses they can take from Iowa colleges. And they also have to have some career experience or experience working with students 14 and above. Mike Cavan there in our office is a good contact for special education teachers specifically wanting this endorsement. But once again, there's exceptions to almost every rule. If you have a special education student that it isn't part of their IEP vocational goal, they're just going to join the class to go out and do work experience, then they can be supervised by a person with the MOC endorsement. We got some rule changes going into effect. These are, we hope, they've been approved so far. We'll know more in August when they get finally approved, but the requirements changing are to make the 3 classes down to 2, so they wouldn't have to take the red one there, and it would reduce the number of hours of vocational experience and give teachers credit for some of their years of experience as a teacher towards getting this endorsement. So that pretty much sums up the requirements for that endorsement. And once again, the purpose of it is to make sure that the students are having that connection between the workplace and the school setting, and that those teachers are responsible for their improvement as they go into the workplace, and that there's a line of communication with the employer for the best interest of the students, of course. Any questions? Once again, if you have specific situations, be glad to talk to you afterwards.
Okay, you've all done very well with your 15 minutes. So we are now opening it up to questions for any one of the panelists. And again, if you write your questions on the note card and we don't get your question fully answered or answered at all, please do turn it in at the end of the session and we will get back to you. So, questions? Yes. Speak loud, please.
I teach industrial technology. We have businesses screaming for employees working on cars, trades. Is there, and they want to pay the students because they know that's the only way they're going to get the students to engage. Are we progressing towards allowing that to happen for 16 and 17-year-olds?
So are you speaking on the liability issue or on the child labor issue?
I'm talking about all of it.
Not the licensure issue, though, so you're off.
I'm worried about the licensure. It's mainly from that liability and the child labor.
So I assume they're over 16,
Correct.
but they're under 18.
Correct. Juniors and seniors in high school.
So did you hear the question?
Well, from our standpoint, Melissa obviously will weigh in, and there are issues there. But from our standpoint, from the insurance, we don't have any rules right now. Will we develop them? Only if there's really a problem developing claims activity. But right now, we don't ask the question, what is the kid going to be doing at what age and so on. So if you want to have kids working on cars when they're 16, that's fine. It doesn't, and since there's no liability involved, it's strictly workers' compensation. So from our standpoint, would the school's workers' compensation apply? Of course it would. Be no restriction on that.
And if to give you some reference, I believe Just Your Insurance covers about 98% of the school districts across the state of Iowa. So we didn't just grab an insurance guy off the street. We do actually have a school insurance expert here. So I just want to make sure.
I was on the street, but she grabbed me anyway. No. Melissa was talking about, if you ask young kids if they can't do something that's maybe unsafe, why they won't do it. Kids will do anything. If you ask them to do something, they'll do it, whether it's safe or not, unfortunately.
Well, if they didn't feel like they could do it safely. That's the goal anyway. As far as, I guess my question is what kind of, when you say that they're working on cars.
Service tech. We've got in New Hampton, we've got a dealer they can't attract service techs there and want to start the students while they're young. Like I said, as a junior or senior when they were 16, and whether it's an hour a day or 2 hours a day, just to introduce that to them and see if that's something that they would enjoy.
So I guess the question is, what machinery that they're using, does it comply with any of the HOs? You know, and if you're talking about some of the, for the most part, I'm not exactly sure that any of them would, besides like maybe hoisting apparatus where you have a car up over your head. That's probably the one that I could most definitely think of would affect as far as, you know, working on a car, because that's definitely and that is HO7, which is not one of the ones that has an exemption. So I guess if they didn't ever have to lift a car up over their head, you know, have it hoisted up. But by the same token, if they're not the one operating it, you know, then there's no problem. It's not like they can't be trained. I guess I don't really know where there's a child labor rule that would necessarily prevent them from being trained how to work on a car, as long as they were, you know, not operating, like I said, the hoisting apparatus, which is usually where we see most auto work coming into play, where they're not allowed to play a part in it. But I don't think that there is any other HO that would apply, off the top of my head anyway. I mean,
Robert, you mentioned that the workman's comp has to do with paying students, and there are some businesses that want to avoid the workman comp side, which the school, it sounds like if we be covered, the student would be covered through the school. Is there, when you say paid, does that include a stipend at the end, or a scholarship, or neither or both? Or is there no clarity on that at this point?
Is paid just have to do with wages, or does a stipend get them around the whole workman's comp, or possibly a scholarship?
If really, when you look at Chapter 85 of the code, it's really talking about pay in the conventional sense. If a student gets a scholarship as a part of his student learning, or as a part of his thing, that to me doesn't bring him a paid employee. It really has to be salary that's going to be reported on a W-2, and if it's not reported on a W-2, I would say he's not paid. And you wouldn't report a scholarship or anything like that. That would
How about a stipend?
a stipend the same way. Yeah.
On that same note, when we're talking about the school workers' comp, I'm not sure if I heard correctly, but you'd said something about if they're getting credit for their work experience. What if they're not getting credit for that work experience? Are they still covered under school workman's comp?
I didn't hear all of that.
She said she was trying to clarify what she heard. She said, does the whole credit portion come into play? If the student is
I
getting
see.
credit for it, that the school's liability would cover them, and if they are doing this activity and that there is no credit, is it still the school liability?
I would say if there's no credit involved, you know, if I'm a student and I'm not getting some kind of credit for a class as part of my curriculum, then I don't think school to work or the provisions of Chapter 85 would come into play. So if that student were just at a place of work on their own, for example, because they want to learn something, that doesn't make it school to work. If they got hurt there, it's totally out of what I was talking about.
No, but they're still they're in school, but they're not in a specific program
But
at school.
like they
So
take
they're
it-
getting credit for that program.
I see.
Are they still covered under?
Well, I'm just going to chime in that if a student took a tour, you know, signed up to take a tour of a place, I mean, that would be the school policy would cover the student for insurance if they got hurt. It isn't a workman's comp thing because they aren't working. So it's just field trip or.
But we have liability
Am I right?
insurance that schools
Yes,
have,
yeah.
but
So
not
that-
school to work from a workers' compensation standpoint. Interesting enough, you know, we talk about kids being covered under the school's workers' compensation policy. As of right now, there's no extra charge or extra endorsement for doing that. It's automatic. It's automatically, as soon as you buy a workers' compensation policy, the coverage is there. And so far, at least, the experience is such that we aren't making any special charge. I'm hoping that that stays that way.
So then is there a distinction between a
it would only be an educational program if there was the correctly licensed teacher in place. So the community member I mean, that's not a school to work program because you don't have the licensed teacher.
Right.
Ava, jump in there. Sorry.
So then how do the intermediaries come in?
No, the intermediary's not the licensed teacher either. They're just making the connections, letting people know.
There's a question back there.
Yes, I'm
Kelly.
sorry.
We started a high school intern program, and one of the issues that I'm dealing with, and this is for Melissa, particularly with HO8.
HO8.
HO8, we're a large manufacturing facility. So with your list of exceptions under machine tools, I read that as 16 and 17-year-olds can do that exception and work on those machine tools. Am I correct?
With the specific machine tools that are in here, yes.
And I'm just thinking, like, some of those machines are quite large, and so I'm trying to convince the people I work with that it's okay, so I just want to make sure I read it right.
Right, and they give you a big giant list here. I'll actually just tear this off and give it to you.
No,
If you want-
I read it 12 times. And maybe it's just a culture of our manufacturing in general. And so when I found that list of machine tools, it was quite surprising that that is an exception. You don't have to be 18.
Right, it's not included as part of that HO8, so.
So you don't have to be a financial student learner, and 16, 17-year-olds can operate those machines.
Yes. It's not even underneath the exemption of, every now and then, you know.
And I realize there's some on there that are not even large. I was thinking,
Right.
here's the HO8.
Yes.
Teresa, you said that they're not going to be part of the student learning
Yeah, they're
program?
not, if we wanted to have them do some of the other HOs that formally have was doing their own action. So, they're really saying, so we're not gonna touch it, but, our large manufacturing facility, the horizontal mill, the lathes, which are rapid spin, are the exception that 16 and 17-year-olds can do it, and there's no minimum age of 18. I was kind of, a lot of people think it's kind of eye-opening, but I think it was too soon.
Question over here.
Yeah, so for unpaid internships, the high school level, students under 18, is there any restriction on the time of day of the experience?
So over 16, under 18,
Correct.
paid experience. Is that what you said?
Non-paid receives high school credit.
Okay. Is there any?
As far as like hours times, no, for 16 and 17-year-olds, there's not. It's just for 14 and 15-year-olds.
So that's even 14 and 15-year-olds would even be with an unpaid internship?
If you have a 14 and 15-year-old, it changes things a little bit because if they're part of an actual program, it has to be a legitimate, work experience program that's been authorized and approved by the DOL. And if it has been, then that there are variants to the hour standards. So you would have to go by the exemption for those hour standards for 14 and 15-year-olds. If you have those in place, if it's an actual program that's approved for 14 and 15-year-olds to do, because it is a little bit different.
But I think she did say unpaid though, and then they wouldn't be under
Unpaid,
FS. It wouldn't be fair labor.
If it's unpaid, I would make sure that it is supposed to be unpaid, I guess, beforehand. But yes, if it's unpaid, then the Fair Labor Standards Act doesn't apply. That whole thing of coverage, like we just talked about, to begin with, it's not in there, so the federal labor law doesn't even apply to you.
Yeah, because
But
they have to be an
if it
employee.
became a paid situation, then you would be looking at our standards.
But if the student is there, even though they're unpaid, if they're doing actual work, that's still okay. I mean, they might be waiting tables, they might be doing all sorts of things.
As long as it is not underneath the criteria of what a paid intern should be, which is why I say I would verify that what you're having them do should be unpaid, because there are very specific guidelines as to what can be unpaid and what can be paid when it comes to internship programs.
What's the best source to get that most updated information?
Me? No. You can contact the DOL, like I for U.S. wage. You can go online to our website, but there's actually a bulletin that was released, the Field Assistance Bulletin that was released, I want to say like 4 or 5 years ago. And it gave very specific guidelines on paid and unpaid internships and how they should be, what should be paid and what should not be paid. And I would look for that. That's what I would look for. I actually have it on my wall at work, but it's very specific.
Okay.
Since nobody else has another question, Dave, you said something about special education, and I thought I heard you say having a goal on their IEP changes things. That confused me a little bit. In other words, Deb has an MOC. She could supervise a special ed student. The nuance here is if there's a goal, she can't. Or she can if he's part of a general ed and a co-top type program.
If the goal is one of those vocational goals, for 14 and up, and it specifically mentions they have to have experience in this type of job or these types of skills, then it has to be the work experience coordinator. But if it's just a general goal of they should get experience in the job play setting, then the MOC can cover that,
Yeah,
because
that's
they're going in
important.
with the gen ed
Okay,
students.
that's important. I wasn't aware of that. That's helpful. Thank you.
Dave, would that also apply to 504?
Nope, 504 is not covered by the work experience coordinator.
Wow, you guys did really, really well. If to take a time out from general questions, Deb Frazier, if you could just, the question you asked about the intermediaries and the community members, I just want to make sure that that I understood your question, because after we finished it, I wasn't sure. You said there was issues with others, or if you can just clarify that a little bit more for me to make sure we've covered that completely, I would appreciate it.
Oftentimes, the schools that we work with believe that they can have the intermediaries help arrange school partnerships, out in the community, whether doing tours or long activities or whatever, and that they can have credit issued for those activities, even though it's not necessarily part of a specific class or definitely not part of a CTE program. And so there's been this gray area of how that plays out. And so, for the liability issues and, all kinds of things, there's been a lot of questions, so.
So to make sure everyone understands, bottom line is when you come back to the education setting, there's got to be somebody licensed to give the credit. If you're given credit, it can't come out of the air, and so an outside banker can't give credit because it's got to be somebody, a licensed teacher. So there have been instances we know that someone is given credit because they are the teacher of record, when in fact they really weren't the ones that was involved. And that really gets you down a slippery slope because they aren't connected and they're not sure they may not know what's going on. The statewide intermediary network is absolutely great for the purposes of I have a student wants a unique opportunity, or they have some time and they'd like to do a tour, or they'd like to do a job shadow. This intermediary person can go help find these connections, come back to the school. Sometimes they actually work directly with the school or with the student, and sometimes it's just more general. But when it comes down to giving credit, it needs to be somebody that's got the connection with the student to know that that's going to be a successful experience, to know how to grade them, to know about all those different things. And typically that kind of thing doesn't happen with a job shadow or a tour, because typically that's not a standalone credit. It's usually when you get into the internship kind of experiences. And that was then Dave Wempen's bailiwick on who exactly it is at the school district that's licensed to give that kind of credit. So.
Scenario there, but
Yeah, well, I mean, that all has to do with how credit is, how courses are marked in the SCED system, and that opens a whole other hour of conversation. But I mean, an MOC endorsement, Dave Wempen will not give it to you unless you are a teacher and so if there is someone there that's MOC certified or could be MOC certified, then that certainly could be the connection. And you just have to have somebody in your district that knows the student that can, be assured that you're not placing a student out there on the job that really shouldn't be in that experience because of other issues that, are going on at the school or other things that you might know. So it really does need to be, for the sake of the program, for the sake of the student, for the sake of the experience, needs to be somebody that's licensed and knows the teacher or student. Lady, go ahead.
One of the problems that we're having as educators and supporting apprenticeships or getting our kids out in internships is teacher licensure. And being able to put students in paths that are meaningful and relevant to what they want to do, and having appropriate licensed adults to be able to support them in doing that. It seems like some of them are so tightly regulated, it's not broad enough that we can encompass to empower all students to walk the path to a career they want through apprenticeship or internship. And something I think we really need to look at state laws and regulations so that we can do a better job of providing students with opportunities for learning and bringing experts out of the field who can support those learnings in the school before kids go out on apprenticeship and internships.
So are you speaking of like the plumber, a fully licensed plumber, and being able, is that the kind of thing you're speaking of? No. Yes.
Well, that would be one example. But being able to look at things, how can we build systems in a broad sense that are supported with specifics? And looking at MOC teachers, I can only imagine how difficult it is for some school districts to find a teacher that can meet those criteria and the school system can pay them so that we can give these kids opportunities.
Well, and that was one of the purposes of our rule revision. We tried to loosen those regulations a bit, yet still make it so they had to have some foundational work behind it. So we get a reputation as being the hammer sometimes. And we really aren't that mean. Unless you let your license expire, then it gets tougher on you. But the MOC, I think, is exactly what you're doing there. You might be underestimating that. That gives any secondary teacher, I was a social studies teacher, if I took the 2 or 3 classes and could prove some experience, I could get the MOC, and would I be an expert on going out and supervising a student on how to be a plumber? No, but I would hopefully use the other resources with the intermediary who had some connections to places to go do that, and with the local plumber they might be placed with. And the MOC's job then is to more talk about the soft skills and how am I going to interact and how am I going to understand the work environment, what's appropriate to talk to the customers about, and being ethical and having the right values to enter that profession. So I think we give a lot of flexibility. We may not get credit for it, but we've given a lot more flexibility to people and have districts add the MOC than maybe has been previously done.
One last question. How long
Yes,
is
Mary.
the MOC once they have that certificate? How long is that?
Well, it's an endorsement added to their license, and so licenses are typically 5-year terms. So if they renew their main teaching license, the MOC endorsement just stays with it.
Okay, they don't have to do it again.
I think the big hand is on the, whatever, 6. So I hope that you got a lot of information out of this session. Thank you very much.